The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello and welcome to Short Circuit, your mostly bi-weekly podcast on the Federal Courts of Appeals. I'm your host, John Ross, joined today by Sheldon Gilbert, the director of the Institute for Justice's Center for Judicial Engagement, as well as special guest William Marra, a litigator at Cooper Kirk. We invited Will onto the show because he argued the first case that we're going to talk about today, which comes out of the Sixth Circuit and involves whether an inmate who says he's being denied full portions of food at mealtimes in retaliation for complaining about a guard can sue that guard. Will, tell us about the case.
Sure. So Mabin versus Thalen was just decided earlier this week in the Sixth Circuit. The case begins in a prison food line. James Mabin, my client, was there to get served food, and the prison, in violation of its policies, was not serving him the full portion. So he raised an oral grievance, and per his version of the facts, which we take as true at this summary judgment stage, the prison guard, Thalen, the defendant in this case, comes over, berates Mabin, tells him, if you're going to complain, I'm going to give you a misconduct ticket, and then issues him a misconduct for creating a disturbance in the prison cafeteria. They then hold a hearing within the prison, and at this hearing, Mr. Mabin, to determine whether Mabin in fact created a disturbance. Mabin had very few procedural rights at this hearing. He could be there and speak on his own behalf, but he could not cross-examine the witnesses against him, compel the production of evidence, or present his own witnesses. The hearing officer, who is a co-worker of Thalen, a prison employee, finds that Mabin in fact created a disturbance, that he wasn't politely filing a grievance, but in fact created a disturbance, and so they punish him. They take away his privileges for a week. So that's the basic factual setting of this case. Mabin then goes to federal court and files a First Amendment retaliation claim, saying, when I was in the cafeteria, I was raising a grievance about the prison food policy, and I was punished pretextually. They said that I created a disturbance, but in fact I did not. And so that formed the basis of his retaliation claim. The district court, Mabin was pro se in the district court, and the district court dismissed his suit, granted summary judgment to the government, primarily based on a Eighth Circuit doctrine called the checkmate doctrine. And the checkmate doctrine says that if the prison has found you guilty of misconduct, and there is some evidence to support that finding, you are categorically foreclosed from arguing that you were in fact retaliated against for the lawful exercise of your First Amendment rights.
It's kind of an ominous name for a doctrine, the checkmate doctrine. Once you've had this hearing, then that's it. You're done. Checkmate.
Sure. So it's basically a sledgehammer that is born out of a concern, at least in the Eighth Circuit case that sort of birthed this doctrine, born out of a concern that we're going to have a lot of frivolous prisoner litigation. And so we need to have a doctrine that's going to say, look, if the prison has found you guilty, we're not going to get into the facts of whether this was pretextual or not.
This case arises in the prison context, but the whole idea of First Amendment retaliation by police or other officials sounds familiar, and it sounds like a case that's pending at the Supreme Court right now. Lozman versus City of Riviera Beach, where a gentleman named Fane Lozman shows up at a city council hearing. He kind of very calmly steps up to the lectern and starts complaining about corruption in government. And a city council woman who had participated in a previous meeting about Mr. Lozman, who they didn't like because he was complaining about some of their property policies, said, we're going to get even with this guy. And then during the hearing, she says to the police officer, come forward. And the police officer arrests Mr. Lozman, and Mr. Lozman ultimately brings a First Amendment retaliation claim, saying that the arrest was pretextual and it was because of his disfavored speech. Can you tell us a little bit about what the issue is at the Supreme Court in that case? And do you see any connection between what's going to happen in the Lozman case and the checkmate doctrine that you've described?
Sure. So as I understand the Lozman case, which didn't come up in the context of the prison case here, is the question there is what are the elements of the retaliation claim, and is the absence of probable cause an element there? In this case, the elements are quite clear. Did you engage in protected conduct? Was there adverse action, and is there causation? And I think that might be partly why this case wasn't raised as a sort of a defense of the checkmate doctrine by the government here. What all of the checkmate doctrine really does is it's a judge-made sort of tweaking of the burden of proof, essentially giving the prisoner a sky-high burden of proof that is going to be very, very difficult to satisfy whenever there's a prison finding of misconduct. And it's particularly difficult, I think, to justify the doctrine, whereas here, Mabin had so few procedural protections. The hearing officer was an employee of the prison, and so it's hard to imbue any sort of, I think, probative value to the finding that was made.
And so, for instance, that hearing officer didn't review the video of the incident in question.
That's right. And so this was an important fact that Judge Clay highlights. He highlighted it at oral argument, and then he highlights it again in the opinion, that the hearing officer, there was a video of what happened. And Mr. Mabin actually said, look at the video and you'll see that I wasn't creating a disturbance, that I was in fact peacefully asking for more food and contesting the prison's food policy. And the hearing officer said, we're not going to review the video because there's no sound. And what we argued is, look, maybe there was no sound, but that doesn't render the video irrelevant. You can certainly see by the way that people are acting, whether he's creating a disturbance, whether Thalen, is being aggressive towards Mabin. And that was part of the reason why the court declined to say that the prison's finding at the hearing had preclusive effect. So Mr. Mabin now, when we go back for a trial, is going to be able to dispute that prison officer's finding that he created a disturbance.
Again, I like this very interesting causation question, because it seems like in your case and in the Lozman case, the government's argument is basically, well, look, maybe there was pretext for the arrest, but then some intervening actor comes in and makes a different assessment, and that assessment should cut off any sort of retaliation liability. So in Lozman's case, sure, the councilwoman is the one who knew Mr. Lozman, didn't like him, told the police officer to come, but if the police officer can then say, but I made my own independent assessment, wink, wink, nudge, nudge, to arrest this individual, even if the councilwoman was basically telling me to do it, the causation is cut off. But everybody seems to know that kind of the fix is in, right? And in a similar situation with your client, you ostensibly have this hearing board that is independent, but is it really independent, or is kind of the fix in? And is this being used to kind of pretend that there's some sort of check on the possibility of First Amendment retaliation when in reality there doesn't seem to be. And that seems to be something that's interesting, and something honestly that the justices at the Lozman oral argument struggled with. One of the examples that took up a lot of the oral argument time in the Lozman case was, well, what happens if we're in a bar brawl and one of the brawlers, yells an epithet at a police officer and says, "You're a pig," and then the police officer arrests that individual, and there's an independent, determination that the individual was doing something that he or she should not have been doing, was engaged in disorderly conduct. How do we disentangle whether or not yelling that epithet at the cop is what caused the person to be arrested versus the conduct itself and whether or not it was pretextual? Now, that's a tougher case than your case. Your case seems like the really easy case, right? And has a lot of the process defects that are not going to occur in some of these tougher cases that the Supreme Court's talking about.
So at oral argument, it didn't seem like it was such an easy case for Judge Sutton. He seemed to think that if you won, there would be a lot of frivolous claims going through.
That's right. That's one of the issues that came up at the oral argument. And I think that there are two responses to that. And I think this goes a little bit also to what Sheldon was saying. And it was a question that Justice Kennedy, I think, was really probing during the Lozman oral argument is, what are the screens that we have available to sort the wheat from the chaff and figure out what are those cases that should be going to trial and which are the ones that we should dismiss as frivolous. And I think the same answer that applies in Lozman applies here. You have the defense of qualified immunity. You have the pleading standards, the motion to dismiss, and the summary judgment standards. In the prisoner context, you have the Prison Litigation Reform Act, which puts some pretty stringent restrictions on the circumstances in which prisoners can file suits, especially if they've previously filed frivolous lawsuits. But then I think the second point, and I think this is a very important point, has to do with the separation of powers. Because there are limits on the extent to which judges can go to achieve the policy objectives that they might want. So even if we were all sympathetic to the Michigan Department of Corrections sort of policy argument, that still leaves the question about whether federal judges have the power to essentially change the burden of proof of a cause of action that is created by the Congress and that is rooted in a First Amendment right of the United States Constitution. And so I think even if those policy concerns get exhausted, we still have this very serious separation of powers concern.
Okay, well, you won. He will indeed be able to take this to trial, so congratulations.
That's right. So you did win, and that seems like it's good news for you, given where you work, Will. You're at the law firm of Cooper Kirk, which has a unique motto that I suspect is important to you, given the fact that you won. Can you tell us the motto of Cooper Kirk?
Sure. So the motto in English is victory or death. But on our
and you're
mugs,
alive, so
and
you
I'm
won.
alive, thankfully. So we'll see what happens in the district court, and hopefully it'll stay that way. But on our mugs, it's usually written in Latin, vincere aut mori. So, but we can use it in either language.
Well, speaking of ominous, is it less ominous in Latin?
It's, I think, a little bit more ominous in Latin.
There's a rumor that after Chuck Cooper, the named partner of your firm and really the face of victory or death, an excellent litigator, once lost a case, and then Chief Justice Roberts said, "So Chuck, victory or death? What happens next?" It's kind of a tough question to ask, and that brings us to another interesting tradition at your firm. I want to know if you brought your sword with you today.
I was going to bring it, but I didn't think it'd be allowed on the metro, so I had to leave it at home. But we do get swords, the associates at the firm. There is a swording ceremony, and we get swords. So I have my sword hanging up in my office.
Now, is it true that lawyers at the firm who have children who are born while they are members of the firm, the babies also get a little mini sword?
You must have a source or something inside Cooper Kirk.
There are plenty of possible sources. Cooper Kirk has been a feeder for individuals in pretty high profile positions over the years. I think there are at least two sitting senators who are alum of Cooper Kirk. There's Senator Ted Cruz. There's Senator Tom Cotton. Who else are kind of prominent alum of Cooper Kirk?
Sure. Yeah, we've been very fortunate to have a number of alums. Noel Francisco, the Solicitor General, used to work at the firm as well. Rachel Brand, Jesse Panuccio, who's at the Department of Justice now. So we have a pretty good group of alums. We've been very fortunate in that regard.
Okay, so let's now move on to the next case, which also comes out of the Sixth Circuit, and it involves the right to an effective lawyer prior to indictment. Sheldon, tell us about the case.
Sure. The defendant in this case robbed 4 Memphis area businesses at gunpoint. After he's caught, he begins entering into... He has an attorney, first of all, and he begins plea bargain discussions with both state and federal authorities. Now, this is where there's a little bit of a factual dispute. The government says that the assistant U.S. attorney over his case reached out to his lawyer and made him an offer and said, we'll give you 15 years in prison if you enter a plea agreement right now. But this plea agreement expires the moment we have an indictment. At that point, you're rolling the dice, and you could end up in prison for a lot longer than that. Now, the criminal defendant says, I never received this news from my counsel, and there's some dispute about whether or not he actually did receive the plea offer. So what we do know is that he did not enter into a plea agreement, and then ended up getting a sentence which was greater than the sentence he would have received if he'd accepted the plea agreement. That's right. So 25 years instead of 15 years. And so after the fact, the defendant says, hey, I didn't have effective counsel before the grand jury indictment. In the stages before there was an indictment, I didn't have effective counsel, and that violates my Sixth Amendment rights. The Sixth Amendment, the Supreme Court has held, protects a right to counsel, and the real question in this case is, when does that right kick in? Does it kick in when the government's investigating you? Does it kick in when you think the government might investigate you? Does it kick in during plea negotiation agreements before charges have been filed or before in an indictment? Or does it kick in at the indictment stage? That's the key question in the case.
Will, what does the Sixth Circuit decide?
So the Sixth Circuit, this is a great, very interesting case with a lot of opinions. It's an en banc case. And the Sixth Circuit holds that the right to counsel does not extend to pre-indictment plea negotiations. And the reason that question matters here is Turner wants to say that he received ineffective assistance of counsel. You can't bring that Strickland claim unless the right to counsel attaches. Because the right to counsel does not attach pre-indictment, he cannot claim that he had ineffective assistance.
So no trial on the merits, it's just done. It's a bar, much like the previous case.
Yeah, the important piece here, and this is a very good opinion and then a very good concurring opinion, but the majority opinion starts out by saying that the defendant wants us, the Sixth Circuit, to overrule 4 decades of precedent, not just our precedent, but the Supreme Court's precedent that the Sixth Amendment right to counsel does not extend to pre-indictment plea negotiations. And the Sixth Circuit says, that's not our job. We can't overturn very clear Sixth Circuit precedent. And I think the Sixth Circuit en banc is absolutely right that that is what the Supreme Court precedent is. But what makes this case really interesting is what happens next. You then get a concurring opinion by a recent Trump appointee, Judge Bush, who files what's called a concurrence dubitante, where he basically says the Sixth Circuit gets it right that this is what the Supreme Court rule is, but I don't think the Supreme Court rule is right, or at least it's questionable enough as an originalist matter that the Supreme Court ought to take another look at this.
I think the originalism analysis in his opinion is really interesting. It's very well researched. He's, just on the bench announcing himself as a serious, deep-thinking originalist judge, and I think one of the lessons here is originalism done well is politically neutral. We have a, quote, conservative judge appointed by a Republican president, and, Justice Scalia loved to say that he was the criminal defense bar's best friend, especially with his decisions, right to confrontation, jury right, and we see that with Judge Bush's opinion here.
Yeah, I think there's there are a few really important lessons to be learned from this concurrence. And Professor John McGinnis has a very good blog post, which we will link to, that kind of lays out why this opinion matters beyond this particular case about a guy who knocked over a bunch of stores outside the Memphis area. And first and foremost, as Will said, this points out that originalism is a theory, reaches results that politics won't necessarily predict. But there are other interesting reasons why we ought to pay a close attention to this opinion. He points out that the opinion shows how, as he says, quote, legal culture changes. This concurrence aids the cert position with which Turner will surely challenge this appellate decision at the Supreme Court. He says it provides incentives for attorneys before appellate courts to bring originalist research to the attention of the court, and it gives scholars even more incentives to do such research because of the greater chance it will make a difference. Look, by the time a case reaches the Supreme Court has what record it has, and if it doesn't have kind of the deep originalist research that John Bush did to say, wait a second, maybe the Supreme Court's precedent is wrong, then the Supreme Court's hands are somewhat tied at that point. And so he reaches this kind of really profound observation that he says that I like a lot. He says, originalism will definitively become our law only when the Supreme Court sits atop a legal culture where inferior courts, litigants, and legal scholars steep their arguments in originalism. And this is something that here at the Institute for Justice, we constantly push for, is for lower court judges to kind of do the hard homework, do the real tough work, to look at what the real historical record is and follow the history where it leads.
I think there's a really interesting puzzle for originalists here, because what we have is an ineffective assistance of counsel claim, and we're trying to understand when you can bring that. But Strickland, the case that announces that you can raise an ineffective assistance of counsel claim, is actually quite difficult to justify on originalist grounds. And so we have to ask the question, how many layers do we pull back? And so the Judge Bush opinion here is being very originalist about when the right attaches. And maybe this just wasn't presented, or maybe Strickland can be justified, but there's an antecedent originalist question, which is, can Turner bring this case at all? And so we have to ask, if we're an originalist, how faint-hearted of an originalist are we? Because if you take this to its endpoint, maybe the claim is actually dismissed for originalist reasons.
Yeah, and that's something that I think, Judge Bush's point, that the Supreme Court ought to do the hard work to figure that out, is terrific. I really like these concurrences dubitante, where federal circuit judges, go to the extra effort to kind of show the homework about why the Supreme Court might be wrong and encourage the Supreme Court to get it right. There is something that circuit court judges can do when they think the Supreme Court's wrong, and that's not what some judges do, which is just ignore the Supreme Court. And I won't name names, but there are plenty of judges who just ignore Supreme Court precedent. But I think John Bush did the right thing here. He said to the Supreme Court, this is a problem. You ought to figure it out.
And there's a humility here, too. He says, to be sure, the sources cited above are not conclusive, and I do not purport to have explored all relevant sources as to when the Sixth Amendment right to counsel attaches, end quote. Originalism is hard. It's hard to do this work, and it takes a lot of people putting their heads together. As you were saying, Sheldon, about having a culture where a lot of judges are doing this and we can get to the right answer. And I think that's another nice piece of sort of the dubitante is we need to think about this a little bit more to make sure that we have the right answer.
Well, let's talk a little bit more about what that hard work actually entails. Like, what are some of the sources that Bush looks into, and what should originalists be looking back towards?
Ooh, this is a fun question because there are a lot of ways that you can answer it. But one thing that I think is really exciting right now is that access to originalist sources is becoming better than ever before because of the transition to a digital world, right? So there are a lot of really fantastic websites out there, like consource.org, which has its ambitious mission, digitizing every originalist document related to the Constitution and making it searchable for people who want to do originalist research. That hasn't been the case in the past, so it's been harder to do originalist research in the past, where you had to, travel to the National Archives, or physically go to the Library of Congress and hunt down these materials in a kind of a painstaking, way. Or take Professor Kurt Lash at the University of Richmond is working on a multi-volume series on all of the originalist documents related to the Reconstruction Amendments. This will be thousands and thousands of pages of documents related to the 13th, 14th, and 15th Amendment that will help litigators and judges and scholars figure out what they mean. And I understand that when these books are published in the next year or so, those books will be those resources will be available digitally as well. So it does require you to really dig into a lot of historical documents to understand what the original public meaning of constitutional provisions are. Kind of the third technological innovation that I would point out is this emerging field of what's often referred to as corpus linguistics, right? And kind of the dean of this field is a justice on the Utah Supreme Court named Tom Lee. He's the son of famed Solicitor General Rex Lee. And basically what this does is creates digital copies of all sorts of different written works that are extant at the time a constitutional provision is adopted. And it provides you the ability for scholars and litigants and judges to do kind of data mining on what the original public meaning of words were, right? How were people using, in an area that's of interest to us, the phrase privileges or immunities in lots of different contexts around the time of the adoption of the 14th Amendment. That's kind of exciting. There's a lot of new opportunities for scholars and litigants to really dig into these resources, but it does require work.
And one of the interesting issues that Judge Bush raises in footnote 24, if anyone is going to look up the opinion, not only what sources do you use, but what sources do you not use. And so he drops a footnote saying that he's intentionally omitting Blackstone's commentaries on the law of England. You know, we usually cite Blackstone if we're doing originalism, but he points out here, quoting Justice Thomas, that the Sixth Amendment was designed to abolish rather than reify the practices at English common law that Blackstone would have talked about. So you need to be careful, I think, both about what you use and what you don't use. Yeah,
it's not enough to say, oh, this is an old resource, therefore it must be good, right? You have to situate it in the historical context. And really, again, most original scholars today say that the question you're trying to ask is, the people who are adopting a particular constitutional provision, not those who are writing it necessarily, not the quote-unquote framers' intent, but the people who are choosing to bind themselves to a constitution, what is it they understood that they were doing? And there's a good argument that in the context of the Sixth Amendment, they understood that they were making a break from the English tradition. And so you can't just say, oh, this is an old document about, this is an old resource about what the law was back then and call it good.
Okay, well, that's a nice historical perspective, and we'll segue right into something very modern, which is the travails of Uber, most recently in the Third Circuit. The Philadelphia cab companies have filed a lawsuit against Uber alleging that they're trying to become a monopoly in that market. Well, that's kind of an amusing claim, Sheldon. Tell us why.
Yeah, so this is a funny lawsuit to me. You have a government-sanctioned monopoly for taxi cab drivers, and Uber drivers don't go and get the taxi cab medallions, which, in many cities, taxi cab medallions are worth millions of dollars in New York City. They're heritable property.
They long had been. They
long had been. Not the case anymore. But because of this government monopoly on who can drive a taxi cab, these medallions, these licenses to drive a taxi cab, have long been worth a lot of money, right? But their worth is tethered to the fact that there's a government regime that artificially limits who can do, taxi driving, right? So you have these companies that benefit from this government created monopoly on taxi cab driving, and Uber comes in with a ride-hailing app that allows individuals to connect who want to drive cars to connect with other individuals who want to ride cars, and it connects the two of them together. And we could say for a later question whether or not the Uber drivers are employees of Uber. That's a different legal question. But Uber comes in and doesn't get these taxi cab medallions for the Uber drivers, right? So they start competing directly with the taxi cabs, and these medallions plummet in value as Uber comes in. So the existing companies that have long held this really valuable government-created monopoly come in and say, hey, when Uber came in and quote-unquote broke the law by not getting these licenses, these medallions, they're the monopolists, right? They're trying to create a monopoly, and we should have a cause of action against them for disrupting our system.
The numbers here are very interesting. October 2014, there were 7,000 taxi drivers in Philadelphia with 1,610 medallions. That's when Uber comes in, October 2014. By October 2016, there are 1,700 Uber drivers in Philadelphia. Medallion rides are down 30%, according to the complaint. medallion value down from $545,000 to $80,000. And the last stat, which I thought was very interesting, was 1,200 taxi drivers had left the taxis to drive for Uber.
The taxi drivers make an interesting claim, which is that they have a property right in excluding competitors, right? That the government created monopoly is actually a property right, and the court has to answer that question. Do you have a property right to exclude competitors? And we kind of enjoyed the court's opinion here at the Institute for Justice because the court cited one of our Institute for Justice cases from another court saying that, no, you don't have a property right to exclude competitors. Competition is what this country's about. And you can't come in and claim that you have a right not to have competition.
And a lot of the taxi drivers' claim stemmed from their allegation that Uber's entry from October 2014 to October 2016, when the law changed, was illegal. That by coming in and essentially breaking the law was the allegation, not resolved in the case. Uber took an unfair competitive advantage in violation of the antitrust laws, and the answer from the court was basically, this is not your cause of action, that the antitrust laws do not provide a cause of action to sue your competitor who might be breaking the law.
Right. If your competitor is breaking the law, then the cause of action is that law, right? Not the separate antitrust laws as kind of a derivative way to go after them for engaging in quote unquote monopolistic activities. Particularly here, where I find the legal arguments by the taxi drivers that Uber was breaking the law pretty dubious. There's a whole debate about whether, as I mentioned, whether Uber drivers are independent contractors or employees of Uber, and whether the Uber is violating different laws about employees. So I thought it was kind of clever, but ultimately not clever enough for the taxi cab drivers to kind of try and get around that, piggyback on that debate, but not have to actually answer it by coming in and bringing this monopoly claim. And I expect we'll see more claims like this outside of the Uber context, just as we have more and more traditional sectors of the economy disrupted by the new digital economy.
And one thing that the taxi cab drivers had to prove here was dangerous probability of achieving monopoly power. And I think it's interesting to think about that, Sheldon, when you talk about these new technologies, especially in the car industry. I mean, we are standing on the edge of a looming revolution in driving. We can all see it coming with self-driving cars. And if Uber doesn't win that race to perfect the self-driving car technology and adopt it, it could go the way of AOL, of BlackBerry, of Prodigy,
and Napster.
Napster. So it's very interesting to see how these antitrust laws can be a poor fit, I think, when you have these very fast-changing technologies that the technology is going to change very differently, particularly with something like Uber, where there aren't the sort of network effects that you see with Facebook or Instagram. Uber is much more like a commodity. The fact that all my friends are using it or not, I don't care as much as I do about, say, with Facebook or Instagram. So the switching costs are a lot easier, I think.
Even with companies where there are higher network effects, like social networks, I have to say that I've heard this argument that Facebook has too much of a monopoly in kind of the social network space, and it's too difficult to dislodge Facebook because of the network effects. And for our listeners, network effects basically mean we care about who else is on the network, right? And because everybody's already on Facebook, it doesn't matter if another network is better or worse. We're going to stick with Facebook because that's where everybody's already at. So they've got that kind of advantage. That said, I remember when the same argument was made about Napster, right? Or and that there's a network effect to having all the different music users on Napster, right? Or about MySpace, right? That everybody's on MySpace. We have to do something to stop this juggernaut, how will poor little companies like Facebook ever compete with MySpace, right? And I'm skeptical that even with entities that have strong network effects, that we can really predict what's going to disrupt those, right? So, to those who are saying, we need to impose new government regulations on Facebook to say, prohibit them from purchasing any other social media network so they don't, get the benefit of that. I kind of think you should remember all of these other examples, whether it's the Microsofts or the MySpaces, where the exact same arguments have been made and life has turned out quite differently.
Right. Those things are very difficult to predict, and the people who come up with that answer end up making billions off of it. So
That's right.
Okay, that concludes the show. Thanks for listening, and be sure to tune in next time for more judicial engagement. Until then, this is John Ross from the Institute for Justice, theorizing that you should get engaged.